Hello, everyone, and a warm welcome to our Fellows Public Talk series. I'm Claudia Rizzini, the Executive Director of the Fellowship Program here at the Radcliffe Institute. Before I introduce the speaker today, as usual, I would like to invite everyone here in the room and on Zoom to ask questions of the speaker. You can do so at any time throughout the program. And to ask questions, you should use the Slido link, which is posted here on the posters in the room, and in the chat feature of the Zoom webinar for our online audience. Thank you. It is my pleasure to introduce Daniel Chen, our Evelyn Green Davis Fellow. If you peer into institutions around the world, you're likely to find a daunting backlog of millions of cases that prolong trials by months, if not years. Not only do backlog violate the right to a timely hearing, but they impose immense economic costs. Trained as both a lawyer and an economist, Daniel Chen is driving new ways of thinking about justice and governance in the modern world by leveraging data science and technology to increase fairness, efficiency, and development impacts in the legal system. In Kenya, where there is a backlog of approximately 500,000 cases and only 700 judges, Daniel developed algorithms and deployed predictive models to diagnose the drivers of delay. The resulting insights increase court efficiency, leading to faster trials and higher wages, highlighting the economic benefits of efficient legal institutions. Daniel is also committed to bringing the power of data science to a broader audience by creating easy-to-use tools that are accessible to students and professionals alike. He is the founder of O3, an open-source platform that has been used in over 2,100 academic publications, which allows users to program psychology experiments, tests, and even multiplayer games without needing extensive coding expertise. During his time at Radcliffe, Daniel will work on a book that synthesizes years of law, economic, and data science research. He explores how machine learning and AI, in tandem with microeconomic concepts, can be used to detect institutional bias, predict judicial decision-making, and quantify the economic impact of improved court efficiency. Daniel hopes that the book can serve as a blueprint for global judicial reform to advance sustainable development and reduce poverty. The Q&A portion of the public talk today will be moderated by Erin Solovey, who is Associate Professor of Computer Science at Worcester Polytechnic University. And now please join me in welcoming Daniel Chen.
All right. So when I was a kid, I used to clip out the weather map every day in the newspaper, so at the end of the year, I could flip through them and look for patterns. Today, I do the same, but with judges. Why? Because American law makes giants of its judges. One might say that presidents come and go, but judges can be forever, since the decisions set precedent and impact people's lives. So this afternoon, I want to pose the question, can AI help courts be fair and just, and unlock the positive effects of justice on economic development? And so let's begin with the definition of justice as equal treatment before the law and equality based on recognition of difference. Using the rubric of machine learning, we can think of a set of x's that should lead to the same predictions, or predictability of outcomes. The x's should improve the predictions. And a set of w's that should not. We tend to think of the x's as consequences of our actions based off the control principle and the merit principle, that we should be liable only for events under our control. And the w's might be race, gender, expressions of our identity, but also events outside of our control like football, weather, the judge's lunchtime, or preceding case. So behavioral anomalies offer an intuitive understanding of future relevance. Psychologists have documented many effects only of moderate size in the lab. So settings where judges are closer to indifference between options or more likely to lead to detectable effects of behavioral bias outside the lab. So let's suppose this parabola captures what the judge thinks is the right sentence. Small deviations cost little. The judge isn't sent to jail. Now suppose the parabola flattens. 8 months, 8 years, I don't care, I'm indifferent. Then as my preferences over the legally relevant factors wanes, the influence of extraneous factors wax. So we can think of measuring behavioral anomalies as documenting revealed preference and difference. So I'm going to illustrate using data collected the last few years, all the cases, 1 million judge votes since 1891 in the US Circuit Courts, 2 billion 8 grams, 5 million citation judges. In the district courts, we have millions of sentencing decisions linked to the available corpora of their opinions since 1923. In the Supreme Court, we have speech patterns of oral arguments since 1955, clipped identical introductory sentences, and ratings of their traits, together with data on asylum, prosecutors, World War I courts-martials, and the Global South. The data comprise a natural laboratory to study normative judgments. You're right or wrong, good or bad. So how do judges make decisions? They follow the law, of course, but not only. They're human, and they're influenced by the weather. Judges deny asylum when it's too hot or too cold. The time of day, they grant asylum more before lunch and less after. The defendant's name, they assign longer sentence lengths to defendants whose first initials match their own. The defendant's birthday, or do the opposite, and give the gift of leniency. NFL football, judges are more lenient the day after their team wins rather than loses. Ramadan, Muslim judges are more lenient the longer is Ramadan. Snap judgments. We can use machine learning to predict asylum decisions with 80% accuracy the date the case opens and when it closes, and predict partisan identity with 75% accuracy using only the judge's writings, consistent with motivated reasoning and motivated decision-making as reflecting the timing of their exits. Elections and wartime also affect decisions. But not only, there's the gambler's fallacy, a well-known tendency for individuals to misperceive random sequences. In other words, any two series of coin flips is equally likely, but people tend to think the sequence at the top with rapid alternations of heads and tails is more likely than the one at the bottom. So if I'm an asylum judge and I grant asylum too much in a row, I might worry I've become too lenient. If I deny asylum too much in a row, I might worry I've become too harsh. So I might actively negatively autocorrelate and just trying to be fair and just. And up to 5% of decisions are reversed due to the gambler's fallacy. In the Supreme Court, the first sentence of lawyers' oral arguments are identical. Mr. Chief Justice, and may it please the court. So we clip these sentences and ask raters to evaluate attractiveness, masculinity, trustworthiness, features that previous research deemed relevant in social settings. And we found that male petitioners below median in masculinity rating are 7 percentage points more likely to win. And Democrats vote against masculine-sounding lawyers. But profit-maximizing firms would tend to erode this correlation by choosing the less masculine-sounding lawyer in order to win. But this negative correlation is stronger in more masculine industries, consistent with their perceiving the masculine-sounding lawyers as winners or having a taste for masculine lawyers. So we ran a debiasing experiment telling the raters after each evaluation whether the lawyer actually won, and we found it reduces misbeliefs, the correlation between masculinity and perceived win rates, but incentives to guess accurately further erodes misbeliefs, which identifies a taste for masculine-sounding lawyers. So what about gender? Female lawyers are also coached to sound more masculine, so do results extend? It turns out less masculine males and more feminine females are more likely to win. And the results are robust to controlling for lawyer characteristics and the best machine learning prediction in the Supreme Court, which also selects perceptions when they're available as features. So besides the voice, there's text. And we can train a language model on the judge's writings And we can see that on the left, the female dimension is associated with migraine, hysterical, morbid, obese, terrified, unemancipated, and battered. And on the right, we can see the male dimensions associated with reserve, industrial, honorable, commanding, conscientious, and duty. So we can do this judge by judge, and we can see that Justice Scalia was an outlier in gender slant. And in the circuit courts, where judges are randomly assigned, judges with more gender slant vote against women's rights issues, assign fewer opinions for females to author, reverse male judges less often, and cite female judges less often. And the results extend to Kenya, where judges favor defendants of their own gender, ruling against women when they exhibit stereotypical gender writing biases. And in India, judges favor defendants who share their last name, exacerbating the disadvantages that low-caste litigants face. So there's at least 5 ways for machine learning to diagnose judicial inattention. Early predictability, so we can predict case outcomes with an equal level of predictive accuracy the date the case opens and when it closes. This suggests that features of a case during a hearing or trial didn't materially affect the judge's rulings. Behavioral anomalies that have a causal influence in the manner just illustrated. Now, if we're inattentive to the litigants, we may also be inattentive to reversals and have implicit risk rankings of our litigants being closer to random, i.e. flipping a coin, and have indifference being greater for certain groups, such as from the Global South. So after surprise reversals, that is a decision that was predicted to be affirmed but happened to be reversed, judges grant more asylum and hold more hearing sessions. Now, judges vary in their responsiveness to reversal. So do less attentive judges have implicit risk rankings being closer to random? So to illustrate this concept, I'm going to take an example from the criminal justice domain where these types of conversations have been more salient. So imagine I'm a prosecutor making the decision to screen someone into the criminal justice system or drop the charges and send them home. Now, if I'm a robot prosecutor making the decision based only on the quote-unquote risk score, the harshest prosecutors on the right, screening in the most individuals into the justice system, would only be releasing the quote-unquote low-risk defendants, the R1s and R2s. As I become more and more lenient, letting out more and more individuals, we might see the R4s and R5s. Now, if we're flipping a coin, we might expect an even distribution of risk scores across each of these different leniency quintiles, and within any quintile, an even distribution of risk scores of R1s to R5s, which may have been what happened by human prosecutors in New Orleans during the 1990s, where the distribution of risk scores for released defendants is similar for the most lenient and least lenient prosecutors. So we can use the same narrative for asylum. Are the lenient asylum judges that are screening in the most individuals into the United States only rejecting the quote-unquote riskiest applicants who should see a low reversal rate of their asylum denials? So what do we find? On the left, judges have strong habits. A judge who's generally lenient in other cases is likely to be lenient in any given case. And on the right, we can assess the implicit risk ranking. So if judges are ordering their asylees, the most lenient judge along the right, letting in the most applicants in the United States, should be rejecting only the, quote, least safe applicants, who should see a lower appeal success, which is what we see among the more attentive judges in blue, but not the less attentive judges in red, who may be more prone to other extraneous factors, such as the weather. And this difference in indifference is greatest for asylees from the Global South. So what about prosecutors? We can see it's a flat diagonal for white defendants, but upward sloping for blacks. And in the bail context, judges released along the right diagonal for white defendants, but not for blacks, where it's flat. So why the wrong diagonal for black defendants? Well, it turns out screening exacerbates the racial sentencing gap. Since black defendants are less likely to have their charges dropped, the real racial disparity magnifies if you impute a 0 for those that are sent home. So is statistical discrimination the reason for disparate screening? Well, we can use the identity of the prosecutor, and we find that white prosecutors are screening in fewer cases on the left that result in shorter sentences on the right. Now, if we're targeting the most severe cases, you might imagine these would have longer sentences. So maybe they're just more lenient in general, but when they're at trial, they obtain longer sentences. Most district attorneys are elected, and they want to appear tough on crime. So why were the white trial prosecutors more effective in this goal? It turns out to be attributable to the identity of the judge. Black trial prosecutors and white judges together render shorter sentences, suggesting the interaction of hierarchy and race. Black trial prosecutors and black judges render similar average sentences as white trial prosecutors do, and they eliminate or reverse the racial sentencing gap, which is hard to explain as statistical discrimination. And turning to the judges, we can see revealed preference and difference. The name letter effect only appears for African Americans with the racial label of N as opposed to B, which highlights the potential for labels that social movements militated for to increase recognition and respect. And in asylum, judges deny refugees the darker the skin tone is relative to that of the prior applicant, and unrepresented parties bear the brunt of judges' mood effects. So we see a number of behavioral anomalies that have influenced judges' rulings, but then there's a factor that's been extremely impactful. By 1990, 40% of federal judges had attended an economics training program, and the results of these seminars were dramatic. We can see economics language used in academic articles become prevalent in opinions. We can see economics trained judges changing how they decided and impacting their peers. We can see economics language traveling from one judge to another and across legal areas. So in economics cases, economics trained judges change by 10% the direction of their votes. So if we teach judges that markets work, they vote to deregulate government. If we teach judges that deterrence works, they become harsher to criminal defendants. So in the district courts, when judges are granted discretion in sentencing, economics trained judges immediately rendered 20% longer sentences relative to their non-economics counterparts. And economics trained judges are harsher to blacks. Now, part of the reason economics was so influential is likely because economic theory provided structure for judges to understand the patterns they saw. But maybe we can go further. If judges are shown these behavioral anomalies, would they become less prone to behavioral bias? If judges are taught the theory underlying the cognitive bias, would they become better judges? Would better justice increase cooperation, trust, recognition, and respect? So in the last century, we've witnessed what Carl Polanyi might call the great transformation of American law, where mentalities changed to be more economical, as reflected in word frequency counts, the writing style, citations to Richard Posner, but also the massive buildup of prisons. So maybe into the next century, AI can bring about the next transformation of law with a focus on legitimacy and fairness. So I'm going to illustrate a couple possibilities through research conducted with a team of computer scientists, economists, and lawyers that work with developing countries' interests in data, machine learning, and randomized control trials to understand the contributions of justice reform towards sustainable development and poverty reduction. The reason we can do so is a confluence of two factors: the shift from paper trails to large-scale data ecosystems, and the advent of machine learning tools that can create interpretable data from unstructured text, even predictive models of decision makers, to better understand inconsistencies and now address them with digital interfaces. So let me give an example of an app that we built as an exercise of practical empathy for the court managers to better understand their frontline justice actors, or the ones that spend more time, more attentive, and thus more successful, or it's not the opposite. But maybe it's another factor that they can toggle, like caseload, or certain types of cases or time periods, or genomic data geospatially, or they can send reports to the conciliators who can share advice, the top performers giving inputs to the bottom performers who can ask structured questions to the top performers. And as a management tool, we can observe the causal hypotheses they wish to explore, and these can often motivate the e-justice innovations to study that focus on efficiency, like WhatsApp access to virtual courts, Uberization of case backlog, apps for missing cases, open access legal search engines, or they focus on training, personalized case-based teaching, and the predict itself. So we follow the model of building institutions that help countries generate their own best policies, open source no-code tools for data entry and decision support, for understanding citizens' preferences, for learning best practices, and for increasing recognition and respect so we can have a more fair and just society. But let me take a step back and ask the motivating questions that drive many of these different innovations. When you look across the world, we see a correlation between economic development and the quality of legal institutions, however you measure it, the enforcement of contracts, the speed of justice, efficiency, and fairness of law. But is this association causal? Does the quality of legal institutions cause economic development? For example, does a 20% decrease in case duration cause a 10% increase in GDP per capita? And if so, why? And what can we do based off this knowledge? And how can we shrink the cycle between historical analyses of observational data to societal change? So a key contemporary question is the potential for digital platforms and AI to increase access, efficiency, and fairness of justice, and reduce market-level constraints to economic development. So I'm going to illustrate with a national randomized trial conducted with the Kenyan judiciary, a national study of India's free legal search, one of the world's largest court construction programs on record, e-justice innovations across Latin America. But the issues of poor quality of legal institutions, they're not limited to a handful of countries. In India, there are 33 million cases pending, where the average case takes 8 years. Pakistan, there are 3 million cases pending, where there's only 3,000 judges. Across the world, the endless adjournments of cases for another hearing session, on frivolous grounds are a major cause of case backlog, as this Kenyan Supreme Court Chief Justice had gone on the record to say. And whether that's due to the litigants, or the lawyers, or the judges, the endless delay creates a problem for rule of law. So what we did was to use data science to identify the greatest sources of court delays and deploy this in a nationwide experiment. When one treatment group, we provided actionable information that is interpretable machine learning based off the algorithms to the courts and the judges. In a second group, we also had accountability. So the same information was further shared to prominent citizens in the community. And a third was the status quo, no information, and this was randomized across all 123 court stations in the country. So can data science reduce information frictions, provide actionable recommendations, and improve the functioning of courts, unlocking the positive effects of justice on economic development? So there is, of course, a large quantitative macroeconomic literature that documents that more effective justice institutions are associated with economic growth. So we contribute to this literature with causal evidence using a randomized trial showing that a more efficacious judiciary can in fact spur developmental outcomes, and we shed light on the mechanisms. So accountability was key for reducing adjournments. And the effect size suggests 20% impacts, and they compound because if you reduce the likelihood of adjourning for another hearing session, that's adjourned for another hearing session, and the mean number of hearings per case is 4.6, this translates into a reduction of 107 days in trial length, or 22%. And the effects persist from 2019 to 2023, and they elevate to a 30% reduction in time to disposition over 4 years, alongside an increase in access to justice. This increase in access and elevated speed doesn't come with adverse impacts on proxies for judicial quality, nor with adverse impacts on citizens' grievances. In fact, the opposite. When asked what suggestions do you have for improving court facilities and services, you see a reduction in complaints about speed and quality, alongside an increase in trust in the courts, especially among the likely users. And turning to the Kenyan Continuous Household Survey that measures wages, industries, and contracts, you see that wages of individuals in a county is positively associated with the proportion of treated court stations in that county. And it happens period by period after the reform. And it's particularly salient in contract-intensive industries that are more reliant on complex economic arrangements necessary for mutually beneficial exchange and development. And the results are robust to different ways of looking at wages. What's particularly interesting is the final column, where individuals are asked if their labor contract is a written contract, a verbal agreement, an implied contract, or not a contract. And we see more written contracts after the reform, which is indicative of citizens feeling more confident asking and receiving contracts. So in a society where only 14% of individuals have a written contract for their work arrangement, despite a 2006 Employment Act that requires, if you've been working for 3 months, you should have it in writing. This highlights how transformative data science for justice, information about the courts, and accountability can be for economic development. So what about information on legal rules? Across the world, access to legal information is limited, and even when available, hard to parse. So can digital platforms offering free legal information improve the rule of law? So we study India, the world's largest common law country, where the vast majority of its citizens lack access to expensive commercial legal search platforms. We study India's Canoon, that was founded by an overseas computer science graduate student in the 2000s. His goal was to bring knowledge of the law to the common person. He basically made a Yahoo search platform, facilitating people to find the most relevant clauses and judgments. Today, it's the first stop for lawyers. The average page gets 6 minutes of view time. The average month gets 2.9 million search queries and 1.5 million search sessions. And turning to balance sheets of firms comprising 70% of India's industrial output, whether you look at firms with at least one case or all the firms, the sizable impacts on assets and reduction of bad debt reinforce the findings of a recent randomized control trial, finding an increase of employment by 12% when 6 months of free legal search was offered to South African firms, highlighting the potential for open source, open access tools that are marginal cost near zero for adaptation and experimentation to be transformative for development. So what about the impact of access to justice? So we study one of the world's largest court construction programs in Kenya, but half of these had exogenous delays due to bad weather, unexpected soil conditions. We see that completed courts experienced 60% more cases filed per day, so that's access to justice, alongside a reduction in case delay by 25%. And an increased court satisfaction and access to justice, particularly for the disadvantaged. So the share of litigants with only primary school education grew substantially to become nationally representative. And firms increased their investment, especially in contract-intensive industries. So we see that court speed matters, but around the world, cases are constantly transferred across judges, and transferred cases increase case duration. But firms randomly assigned to faster judicial panels increase their productivity by 10%. So how can we increase court effectiveness? Many countries use productivity quotas, and judges do respond to them, but hastily. At the end of the month, these hastened decisions are more likely to be appealed and adversely impact the firms. So is there a smoother way? What about dynamic point systems where the case's points accrue as it gets older or the evidence might expire, applying sharing economy principles to balance workload across courts or across judges, a legal Uber app, leveraging intrinsic motivation to work on certain types of cases or days of the week, or a top-down approach recommending justice actors to cases based on their value added. So to do this, we need data, but in many countries, it's in scattered Excel sheets that are disharmonized. But with open source tools, you can harmonize the data entry and automate decision dashboards. And in Kenya, this increased the speed in appointments, reducing case delay without adverse effects. So what about dashboards by themselves? Seeing statistics about the self increased settlement rates among conciliators in Peru, whose job is to increase settlement rates. It increases case clearance rates for judges in Chile. So simple e-just innovations can enhance judicial state capacity. What about e-courts? So e-filing reduces case duration and increases access to justice, particularly for smaller parties who don't have to travel long distances to the local court. What about e-courts? Or during COVID, Chile innovated with WhatsApp access to courts, Q&A, video and audio enabled. The call receivers were given text to copy and paste, which raises the potential for chatbots to support the humans at night or on weekends when they're not working. The documents are linked across calls into the courts, facilitating downstream analyses on consequences. And during COVID, 40% of the calls were gender-related, as was rolled out nationally, to improve the speed of justice. And a WhatsApp RCT improves dispute resolution and fiscal recovery for the Indian state. So from WhatsApp to Zoom to the metaverse, as this Colombian court recently innovated, raising the possibility of personalizing debiasing to the ear of the listener or the eye of the viewer. Cognitive psychology suggests we have imperfect reasoning capacities, gambler's fallacy, mood, time of day, order. They all highlight the fragility of the courts, where even in the US, there could be but 7 minutes to decide a family's future. Policy discussion tends to revolve around having AI replace humans or suggest the optimal decision. Consider instead an incremental approach based on enlightenment and romantic ideals of the self, self-knowledge, self-expression, self-understanding, self-improvement. So in stage 1, we might begin with the predicted self, using only the legally relevant features, X, at the very least, help the judges be their better selves. Increasing consistency, cabining the influence of those extraneous factors, those Ws. Seeing the predicted self can leverage self-image motives of post-social decision makers, and deviating from the default can facilitate conscious deliberation. In stage 2, we can use all the features, the X's and the W's, and if you make a decision that's likely to be erroneous or biased, you can nudge them, pay more attention, are you sure? Rather than a checklist that might impose bandwidth, reducing energy on novel and complex cases. In stage 3, we can have explanations, interpretable machine learning, elevating AI to a coach on why you're nudging me. Psychology finds the more people feel their autonomy is protected, that they're in control of the conversation, able to choose when feedback is given, the better they respond to it. In stage 4, we can have a dialectic. It's always possible the AI bakes in the past, ignoring changed circumstances, reliable private information. And so you can encourage a decision maker to express themselves why they're deviating from this nudge, so the AI can learn from the user. In stage 5, we can have a community of experts. So you can have a predicted self, then you have the predicted others, or digital role model, or a statistical distribution to protect privacy, or use this to train novices who might make more mistakes, have the experts input a preferred decision, open it to the public for accountability, or use feedback from the dialogue stage as a recommender system with A/B testing to generate causal inference on what are the changed circumstances that are most beneficial for the litigants. So A/B testing is very common in the justice system. Decisions are not random, but judges are randomly assigned, and they have strong habits. So sentencing decisions aren't random, but if you assign a case to a judge that's predicted to be harsh or predicted to be lenient, then you can look at what happens to their downstream wages, education, health, and families. So biographies predict church-state separation decisions, but you don't have to use just biographies. You have a whole history of how they write or cite in a machine learning step to predict those decisions, and then a second step, do causal inference. So on the left, we do a pretty good job at predicting environmental rulings. And on the right, you can see that if you assign a pro-environmental judge, that reduces air pollution. You can do this for India, where you lack biographical data, but you have how they write. And you can see that those that are predicted to be green cluster together and assign them effects verdicts, which temporarily reduces pollution and firm activity, consistent with environmental litigation as scrutiny. raising the potential for automated impact analysis, locating the nearest past cases for an incoming case, the assignment of judges to those past cases, predicting the rulings to identify the consequences of decisions on the current case. And when informing judges about the impacts of their decisions, increase their intrinsic motivation. So renewed attention on disparities in the justice system has put forefront the role of training of public officials. Globally an issue, the US alone allocates $10 billion per year towards training civil servants. But despite its significance, there's little empirical research on what works using randomized trials. So besides selection, incentives, and monitoring, we think there's space to think about attitudes, preferences, and beliefs, the schools of thought that underlie decision-making, such as economics. So economics trained public servants to use economics language and opinions, decided against regulations, issued longer sentences, and were more disparate in sentencing. So what about in economics not focusing only on theory, but also on data, such as econometrics? So we trained deputy ministers in Pakistan in a school of thought associated with the credibility revolution through a book lottery, videos by the authors, social emotional learning exercises. So you summarize the lessons of the book, you visualize how the book applies to your future career, and you self-persuade, explaining it to your colleagues. And we found it increased their demand for causal evidence, it increased their responsiveness to causal evidence, they treated policymakers' performance in national research method exams improves, and their willingness to commission RCTs in policymaking increases. And in their official duties, they're twice as likely to choose and triple funding for policies with RCT evidence, in this case, deworming. And the results extend to tax officers, where econometrics education led to a 20% increase in the use of tax reminders, which previous research has documented to be effective in collecting tax. In this case, a 40% increase in tax collection. So what are friendlier economics? Not a 1970s Chicago economics focusing on the theory of deterrence, but one that imagines how decisions might be best for your organization or society as a whole, formerly referred to as effective altruism. So randomizing schools of thought on cultivating post-sociality found that training effective altruism via the utilitarian value of empathy renders greater altruism. They were more likely to donate blood, but only when the blood bank called for the matching blood type, consistent with their mentalizing on the consequences of decisions. If I go to the blood bank during COVID, is it actually going to be beneficial? Perspective taking and strategic dilemmas, cooperation, coordination improved, and we saw altruism in action. Orphanage visits and volunteering increased, and amid the official duties, they were more likely to choose social policies and recommend fourfold funding for them. And the book lottery illustrates the mechanism. The long-term effects on policy are only affected if the book was assigned, suggesting the demand for learning, this curiosity to learn more about empathy and to practice it, is driving the long-term impacts. So what about AI training? So not just causal inference. We can see that AI training and AI fairness activism impacts the AI attitudes of ministers and their subordinates. And amid land record digitization efforts, we can see it impacts their funding for digitization, which then impacts the citizens. AI training improves the resolution of land disputes, now that you're able to look up who owns what, by 32% in resolution time, while AI fairness activism worsens it, highlighting the unintended consequences of schools of thought, however well-intended, can impacting citizens' lives. There's one school of thought that's been impacting half the world's population, the women's rights movement, but slow progress in some places speak to the stickiness of norms. So can we shift the attitudes of frontline civil servants? So we used a visual narrative, a best-selling film partly developed at Johns Hopkins University, and a curricular outline. We found it shifted the teachers' attitudes. They're more likely to sign petitions to criminalize dowry, abolish polygamy, their gender IIT scores, and the attitudes are obliquely transmitted to the students. Role models could potentially explain the oblique transmission, even when only the teachers are only assigned to the visual narrative. And this improves student achievement, but only for mixed gender study groups, meaning they're having the opportunity to practice these progressive gender rights, and it increases cooperation and coordination with the opposite gender. So are there principles that extended the training of judges and apply to human-centric AI? Self-reflection, demand for learning, social-emotional learning, community for norm change. So I'm going to highlight a couple experiments we ran with the Judicial Training Academy of Peru as they were shifting from theory to case-based teaching. Socratic method, voluntary self-reflection, community of practice that touch on some of the different stages of incremental AI. So in this 2-year engagement, we conducted 3 light touch interventions: Socratic method, focusing on reflective inquiry, asking them to think critically about their own assumptions, the teacher's assumptions, the classmates' assumptions, as opposed to just telling them to focus on the teacher's ideas and take notes. And we found it increases the students' passage rates, increasing their grades by 0.2 standardized units, and the click data shows larger treatment effects for those who finished the 4-minute video. And it increases their curiosity, reducing motivated reasoning as they requested additional information on a Supreme Court case vignette. Community of practice, a pedagogical innovation focusing on regular concrete learning from peers, in this case for the teachers that were innovating with a new case-based methodology. So practicing role play, encouraging student participation. And we found that treatment increased grades and satisfaction, increased case clearance rates of the judges over this 8-month-long training program. The effects are larger for females, as potentially the better practice of student participation is getting more mixed group participation. And it reduces gender IT bias, especially for male judges and prosecutors, having the potential for these mixed groups with active participation to reduce implicit bias in high-stakes decision makers. So about directly addressing implicit bias that can underlie stereotypes, predictability, and inattentiveness. So there's mixed evidence on the efficacy of implicit bias training programs, potentially due to their compulsory self-reflection. But when we're able to choose when feedback is given, the better we respond to it. So does a choice to learn about implicit bias reduce implicit bias? So judges randomly assigned to have the option to take the IETs became less biased in their IETs. So putting this together, what about personalized case-based teaching using the tools of machine learning to show a judge what are their decisions most similar to the case that's being taught in the academy? How do the decisions differ? Are they missing fact patterns? Are they missing laws? Showing them the predicted self. Bringing case-based teaching to the next level, allowing them to reflect on how their assumptions might differ, or community of practice. Role models. You can get predictions of others if you can do predictions of self. Cultivating a culture of precedent. So we see a couple of ways on how AI can increase access, efficiency, and consistency of justice, and reduce market-level constraints to economic development. But in the last 50 years, we've seen an increase and decrease by multilateral organizations' interest in justice reform. But given the sizable economic benefits and the intrinsic value of justice, should we invest more in justice? And more importantly, how can we reimagine justice together? So thank you.
Hello. Hello. Wow. Well, thank you so much for this talk. Sorry, let me get this set up. So it was a great talk, and we've got a lot of questions, and we'll try to get through some of them. But first of all, that was a lot of material. So can you give us one TLDR that you hope we take away?
I think the first third to emphasize that humans can also be extremely biased, but then the last 2/3, how we can reimagine how AI can help us be our better selves.
Okay.
So.
Okay, great. I think that would be really helpful, and I think that's a positive way to use AI. So how do we make sure that the AI that's created by humans who are biased doesn't actually reinforce the human bias?
Yeah. So in that stage 1 slide from whatever, minute 26, was essentially trying to argue that the predicted self might be a way we can cabin sort of the noise or those W's that can affect humans. And there's actually statistical and econometric ways that you can use the historical data to assess if you were to replace the human decision makers from the historical data with the predicted self, would it actually have been less biased? And that's certainly like a stage 0 for those who do clinical medicine, on like first seeing if it's actually potentially better.
Okay, and so how do you define
better?
And
great.
how do you know, how do you identify all of the bias? Yeah.
Okay, well that segues a little bit to how we get some of these projects to work is, through curious bureaucrats who sort of cultivate the inner child. And we share apps that get them super excited to like share more data. And we ask, well, why is this interesting? What do you think it affects? And how would we know? And what are the possible downsides? What are the possible biases that you might want to try to capture? And so operationalizing that through a Socratic dialogue with policymakers is one way to try to get at the bias question. There are other ways as well.
Okay. There are a few questions related to that. Let me see. So I guess if you, in terms of moving from a human, so you talked about the human judge learning from their data and their biases, but then you also got all the way to potentially AI replacing the human judge, or that being a question. So are we on a path to AI being the judge, or?
So I don't think I was intending to convey that last point.
Okay.
The articles with colleagues, including anthropologists, was definitely trying to emphasize that it's this digital community of practice. You're not necessarily needing to have the AI replace the human, and even some of those other variations involve there's a academy or sort of appeals board that kind of nudges them to think a little bit more about what is the right decision in any given case.
So the role of the AI is sort of collaborator or instructor, or what is the role of
like a co-pilot?
Co-pilot. Because there were some questions about, if you're using AI in these situations, can you talk about the reliability and accountability aspects of that, and who's accountable if the AI steers you in the wrong direction or in the right direction, and the reliability of decisions based on AI?
Sure. So accountability can have at least 3 variations here, right? So one is the judges being accountable to, say, like the Supreme Court or whoever the judiciary / committee, such that they're able to observe their decision patterns, their biases, and so forth. Then there's accountability to the broader public, and that's also kind of an open question, especially vis-a-vis the algorithms of the data science. I might lean a little bit more towards openness and accountability to that, and probably the other third dimensions like programmers and their accountability.
Right. So if, for example, so we see this coming up a lot more when AI is integrated into like safety situations, like autonomous driving or something. So if it makes a mistake, even though it's good most of the time, but it makes a mistake, then you have to think about whose fault is it. So I guess so when you say it goes up to the people, like how do you hold the algorithm accountable?
I would think and I would defer to the legal scholars here who've thought heavily about liability and previous forms of technology and how those rules play out. Probably a lot of this is going to change with norms as people get more and more used to either the technology being kind of, too sort of familiar, but at the same time, if you are getting the human to sort of, look, the whole purpose of this was to get you to think harder, then in that sense, the human would be more accountable. But that's a 1-cent answer.
Okay. Yes, so there's so many questions. Sorry, I'm just trying to scan through so we get a few different topics. I guess I'm interested, you talked about a lot of things. Is there anything in here that you didn't get to fit in that you wanted to bring, that you think is really important to discuss?
Sure. So I'm really interested in normative capital underlying the judiciary. So you can think of what I was presenting, physical capital, human capital, sort of the digital infrastructure and how people transform inputs they see around them into decisions. But another dimension that's super important is like trust and legitimacy. And I haven't talked about that. There are ways people use surveys to measure that, and I think I touched on that in some of the slides, but I'm really interested to think about how we can better measure that. In part, if you start conceptualizing legitimacy as people complying with the law apart from the possible sanctions or economic consequences, which is close to things like deontological motivations and duty. So that's a whole nother agenda.
Okay, so like, what's an example of one of those motivations, just to, for people who are not?
Sure, a paper I started in law school was looking at, during World War I, the British military, they sentenced several thousand people to death for desertion, but only 10% were executed. We have the names of the soldiers who were executed and not, and we can see that Irish soldiers, upon having this execution, they were more likely to desert. So kind of showing that this undermined the legitimacy of, sorry, that's like one, but there's obviously other settings that Tom Tyler and many other contemporary criminal justice research scholars are thinking about when they operationalize the idea of legitimacy.
Okay, so thank you. So another question is here about, there's a statement that these are such important observations that you've shown to all of us. And then the question asks, I wonder what assumptions we might be making about causality when we observe changes in decision-making and the variables we are not measuring, and how to account for the bias in these unmeasured variables.
Okay. I interpret this question as, so in the first part, I alluded to randomization of cases to judges on occasion, but you definitely need to have that to try to cabin, like, are there emitted variables that might be driving the patterns that we see? Whoever asked that question, I would encourage unpacking that.
Okay. And I guess that gets to a question that I've had about, with a lot of the data, so in terms of all these algorithms and the machine learning that's being used, it's all based on data. So I was interested, what is this data? What does the data look like that this is being trained on? Because that gets into, then can we identify what's not measured and what's not in there?
Right. So I guess I'm, as a data rat, kind of more of an advocate towards trying to get as much data as we can to be digitalized, and then we can try to understand what are the, how the judges, all that framework from the beginning on thinking about inattention and when these other factors might be influencing, and if we're worried about things that are not, why, if we're 80% accuracy the date the case opens versus closes, well, what is the other 20%? Should we be trying to get more and more data such that if we're sort of making an intervention that these asylum judges are not that attentive, then maybe we try to get more data. Or if the hearing data is not sort of all that helpful, then maybe we're not collecting the right data during hearing.
Yeah, so, and I'm not in this field, so
yes.
What is the data? Is it literally the text?
Could be text data, briefs, could be the opinions, could be the audio data, the oral arguments, could be defendants, et cetera. There's lots of data.
Okay. Yeah, and I think that this, gets at one of the things with messy data that was maybe taken from, for different purposes. So it wasn't written down to train an algorithm, similar to, I think, in medical records too. We have lots of notes and things like that. And then I think it's interesting to just think about what didn't get written down or didn't get recorded that maybe happens in the human decision maker. So it's not really a
Oh,
question.
but that then speaks to your research.
Well,
yeah, Aaron's doing work on like FNIRs and how wearables could possibly help notice if someone's fatigued. That's part of a whole new set of
Yes,
ideas that I think even since the summer has been playing with some new ideas.
Yeah. I'm always interested in, we're trying to model, in a lot of the data I deal with too, it's just, you're trying to model a human decision or something really complicated, and we can do a lot with the data we have, but there's still stuff missing that could augment it. And then another question was, if we're doing this and we start getting more and more reliant on AI guides and decision making, is there a risk that we no longer have that human expertise that we're still training on? So if humans start more and more using these AI assistants in these situations, will we have the experts to train our future models?
I think we underestimate the ingenuity of humans. They come up with new situations that aren't captured in the past.
Okay. Thank you for all the questions. So there was a question, I think, related to the data that you showed about gender bias. And is there, in terms of, you were talking about maybe you select the person that argues the case based on whether you think that the voice or the gender matters. So is there a difference in who argues a case depending on the firm's perceived strength of the argument?
Yeah. So firstly, it's not causal, that project. So we're just showing descriptively what we see.
Okay.
And then secondly, the part where we add as a control the best machine learning prediction of the Supreme Court, that's essentially trying to control for all the things that people have already looked at, including what's the previous experience of the case in the lower courts / like strength. But for sure, there's more work that needs to be done. And if ever there were the metaverse where you could randomize that, then you could see if there's a causal effect.
Oh, so I think I might have missed it. So you're saying in the metaverse they might actually change the
Oh,
characteristics?
no, they don't. But
Oh.
as a scientific platform, one could consider if there's actually a causally effect in someone's rulings.
Interesting. And in your research, did you analyze the effect of political and financial corruption on your judicial decision making?
We have some ongoing projects on conflicts of interest.
Say more. It sounds like there's some interest.
Well, we're digitalizing. This is U.S. data where we have financial disclosures of conflicts of interest. You can also identify the expert witnesses, pulling that. So it's a big data exercise from the last year.
Interesting. Okay, so I think we have time for maybe one more. So I guess to close with our last question. So, we've been at Radcliffe for a few weeks now. What are some of the new ideas that have been inspired by Radcliffe, by your experience here so far, and what can we do together this year?
So I'd love to reimagine justice with everyone here. Even in the last couple of months, run into psychologists and physiologists that were coincidentally both using time deception experiments, which is related to the theory of interoception, but that's led to some ideas. There's this common trope of judicial fatigue driving bias, and so there's maybe some HCI interventions that could address that. Last Friday's computer science professor Radcliffe Fellows presentation on steerable ChatGPT actually has some resonance with the personalized case-based teaching. And then even the last 3 lectures, I've been thinking, how can we amplify the voices of stories that often are socially constrained and muted, which is a little bit related to the apps for missing case that I highlighted on this slide. But really excited to have more conversations and be inspired more.
Okay, well, I guess that's all the time we have. So thank you, Daniel, for your interesting presentation and perspectives. I want to thank our audience for all their terrific questions. And I hope you'll be able to join us for other Radcliffe virtual programs. You can find out about future programs and watch videos of past events at radcliffe.harvard.edu. Thank you again for joining us today, and have a good rest of the day.